welcome to Pariksha, and today we will discuss the frequently asked questions on patents. So basically it's a revision video for the students who are preparing for CGPDTM exam, and it will be like on patents. So as you might see that this PDF is 34 pages long, so I'm not going to finish this PDF in a single video. We will make a maximum 8-minute video, and we will try to like finish as soon as and in less video in which we can finish it. So we will start with the without wasting time and with the video. So let's for the first question come up is what is patent. So everyone must of you will be like clear what is patent and all. So let's revise it. So we are revising everything from like scratch, so that the student who haven't prepared at that time can see it and now prepare for it. So a patent is a statutory right for an invention granted for a limited period of time and to the patentee by government in exchange of full disclosure of his invention for excluding others and making, using, selling, importing the patent product on process of producing and all. And the important things I have marked here. So you can take two things. The red one is something which is important, and the things which are marked other than red color are more important. So what is the term of Indian patent system? So the term of a patent is granted is 20 years from the date of filing application, and PCT, Patent Cooperation Treaty, like the member states who signed this treaty, like the term of patent will be 20 years from the international filing date according under PCT. Now the question terms comes, what is the international filing date? So international filing date is the date on which we file application to the PCT, and under PCT we can file in the, I guess there are 153 member nation, so we can file in all the 153 member nation by filing a single application under PCT. So now the third question is which act governs the patent system in India? So the patent system in India is governed by the Patent Act 1970, rule number 39 of Act 1970, much like to the point. Does Indian patent give protection worldwide? Patent protection is a territorial right, so you must remember this thing. And as I told earlier also, from making these points, I have made like 27 questions that have came through my notes to the in the last patent exam that held and which was eventually cancelled. So patent protection is a territorial right, and therefore it is effective only within the territory of India. There is no concept of global region. So what you have to note here is when you file patent in India, so it is only territorial right under India continent only, in India country, India only, and there is no global patent until and unless. uh, Now, however, filing an application in India enables the applicant to file a corresponding application for same invention in convention countries under PCT. So note here, like before filing PCT, you have to file a patent application in your country. Only then you will be eligible to file a patent under PCT. And it should be filed within or before the expiry of 12 months from the date of filing in India. Now, what can be patented? So, invention relating either to a product or process that is new, involving inventive step and capable of industrial application can be patented. However, it must not fall in the category of invention that are not patentable under Section 3 and 4. So, what are Section 3? Section 3, 3A to 3P are the uh, acts, goods that are not patentable, like agricultural, medical, and plant species and all. And under Section 4, atomic related patents are come. So these are not patentable. So what is the criteria of patentability? So I guess you all must be aware, but let's again do it. So an invention is patentable subject matter if it meets the following criteria. It should be novel. It should be novel means new. New means something that you have created. Like if I say, if any optimization method you create, so it can also be a patentable method until unless it's not a computer program. So when the question like this comes, like what are patentable methods and what are computer programs. So if you are inventing some novel patent optimization method, so it can be patented. Now, it should have inventive step or it must be non-obvious. So when we are filing patent, so the inventive step that you are suggesting or giving in specification should be obvious, and it should be like visible, like it is a inventive step, and you should include the background study as well. And it is capable of industrial application, like if you are patenting something, so it should be industrial, capable of industrial application. And it should not attack the provision of section 3 and 4 of patent act 1970. So this section 3 and 4 are coming everywhere, so you must be aware of what is section 3 and 4 are clearly. So for that I have added this comment. So section 3 is non-patentable items, that is agriculture, medicine, computer program, as I told earlier. And for question 7, the below question is on that. And section 4 is atomic energy. Now, what type of invention are not patentable in India? So, an invention which is frivolous or which claims anything obviously contrary to well-established natural laws. So, I guess this statement must be clear. Like anything which is like, if sun is rising from east, so it should be rising from east only. You can't say that sun is rising from south and all. So, these are natural laws to which our patent should not like contra. And an invention, the primary or intended use of commercial exploitation of which could be contrary to public. Now you have filed any patent, or you have invented a method by which you can cure cancer by using something that can kill to some animal. So that is that cannot be suggested as like patent or anything, because it is harming something. For 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 getting to your result of your patent, as you have told, you are harming something. So that should not be that should be exploitation. So it will not be patented. Now, third one is the mere discovery of scientific principle or formulation of an abstract theory or discovery of any living or thing. So any living thing, if you discover any living species or any animal or anything, or any like principle upon the uh, living being, like any principle of their respiration or their excretion, so you cannot patent that. No. So also, for the purpose of this clause, salt, ester, ether, polymorphs, metabolites, pure form, particle size, isomer, mixture of isomer, complexes, combination, and other derivatives of known substance shall be considered to be the same substance. So substance from the same category, like when you are talking about salts, it will be covering all the salts. When you are talking about chemicals, it will cover all the chemicals, and you cannot like some that this is different and this is, until unless it is significantly differentiating. Now let's come to the this point, and it is, can any invention be patented after publication or display in the public exhibition? Yes. However, generally, an invention which has been either published or publicly displayed cannot be patented. So here you must be aware, like a similar thing is available in other acts as well, design, copyright, and where you we say like ki we can file the copyright for something which is have been communicated before to the head, but here things differ. So you must be aware, and I will tell you to write those things together so that you will be able to differentiate these things easily. So generally, an invention which has been either published or publicly displayed cannot be patented, as such publication or display may lead to lack of novelty. However, under certain circumstances, the Patent Act provides a grace period of 12 months for filing of patent application from date of its publication in journal or its display in an exhibition organized by government and disclosed before any learned society or published applicant. So this is things to be noted. And does the patent office keep information? Obviously they take. So, and they kept secret it for until 18 months, and then they publish. And so it's open for public after that for any counter. Is it necessary to visit Indian Patent Office? No, it is not necessary. So this question is from patent heritage point of view, so we are not taking this. Now you can remember the website, because I remember an exam in which they have directly asked, it was some ICMR exam in which they have asked what is the website of ICM. So remember the website. It is ipindia.nic.in when you are talking about IP website. What are the other contents of patent of agenda? The patent of agenda contain information related to patent application which are published under section 11A post grant act publication, and restoration of patent notification list of non-working patent. So this is the contents that are included in the patent of agenda. So from till here we will stop today, and we will again continue from page 7, filing related information, because it's already crosses the 10 minutes. So okay. And thank you for, please like and subscribe and share as much as you can. We will be sharing more information about the patents, and once I cross the 500 subscriber on this Pariksha page, I will be sharing all the PDFs from which that we have like we are able to get 27 question in the exams. Thank you.